unconstitutional.
Justice Kagan?
So just on your last point, Mr. Katyal, I took Ms. Harris to be saying, with respect to your analogs at Bruin Step 2, that her principal point was, look, it's not about, like, is it about poaching? But the difference between those laws and this law is that those laws were about lands that were closed to the public. And that was her principal point, that made that like just a different category.
Right, and it just blows off the word improved in the statutes. It's not just about it's not just about fenced land, but improved land. For improved land, the statutes did change the default rule and say you couldn't imply the consent of the owner. And as Professor Hertog said, that applied to stores, it applied to plantations, indeed that's the definition of plantations, and it applied to premises, which is another word used in some of these statutes. And so the idea that it didn't apply to these types of things that are just like what my friends are challenging is just wrong.
Okay. And on this, your Step 1 inquiry, which I find interesting and difficult, I mean, I think somebody could say, look, what these consent flipping, default flipping rules do, they do burden the carrying of firearms. And that's what they are. And to incorporate the burden into one's understanding of the scope of the right is a kind of category mistake. That the burden is supposed to be at Step 2, and these are burdens on the carrying of firearms.
So two things. One, factually, we just fundamentally disagree that this burdens firearms. As Justice Alito was saying earlier, if people in Hawaii don't want to have the guns anyway, they're always going to be able to, even under their rule, say, have signs that say no guns allowed. So either way, you could have that burden. The second thing is legally, this court has made clear as day at page 22 of Bruin, you can't ask that burden test. Here's the language. You said, quote, Heller and McDonald expressly rejected the application of any judge-empowering interest-balancing inquiry that asks whether the statute burdens a protected interest in a way. And so, that which my friend is definitely trying to say, that this burdens the right, that is not a Second Amendment violation. That's going down the road of undue burdens that this court has criticized in a separate number of contexts and saying that's a smokescreen for policy judges' preferences. Rather, the inquiry at Bruin Step 1 has always been text is informed by history. And when you ask yourself what in the text informed by history this Hawaii law violates, the answer is precious zero. No commentator, no treatise, no court, no one's ever said you have a right to imply consent of the private property owner. And rather, the fundamental tradition, which Justice Sotomayor was saying earlier, that Justice Scalia recognized in the Jardines opinion, is that there's a fundamental right to exclude, and that right to exclude has always meant, at the time of taverns and the like, you can exclude people for violating the terms on which they come in, even if your tavern's open to the public.